that, and now we're going to be looking at anti-graft agencies in Nigeria. And we're going to be looking at, what it entails when convicting offenders in court. Now, joining us via Zoom this morning from Birnin Kebbi is Muhammad Usman. He is a legal practitioner. Good morning and welcome to the program.
Good morning, and thank you for having me.
All right. Now let's start with anti-graft agencies. Now, of course, we know when we say anti-graft agencies, we're talking about agencies like EFCC and the rest. But most Nigerians might not really understand what it entails when you say anti-graft agency. So, can you just give like an overview of what their roles are and what they do in the society?
Good morning. Anti-graft agencies are basically state institutions that are saddled with the legal responsibility of investigating and also digging out issues that are related to financially related crimes. And that is why in the wisdom of the legislatures, they come up, I think in the year 2020, with the ICPC Act, which gave rise to the making of the ICPC as an institution that is saddled with the main function of tackling and also battling with crimes that has to do with finances within the country. And also the EFCC Act, which brought about the Economic and Financial Crimes Commission, that is also saddled with that similar responsibility. So the whole essence and the functions of these agencies are to streamline their activities within finances and issues that have to do with frauds related to finances and everything related to finances. As far as the state is concerned, is to reverse the catastrophic effect of corruption and other corrupt practices that has bedeviled the system over time. So this is what brought about essentially these primary institutions that are saddled with the duty or responsibilities of battling or tackling issues that has to do with corruptions and corrupt practices, especially as it's related to finances in and outside the forests of the government.
All right. Now, you've mentioned the EFCC and ICPC, and they both, of course, handle corruption cases and, issues around finances as well. But, most people confuse their roles and what exactly they do. So, or how do the mandates of the EFCC and the ICPC differ? What is that thing that separates the two of them, and the roles that they perform?
Basically, the primary functions are virtually the same. In fact, that is why of recent, a lot of people must have heard the calls for harmonizing the institutions, because it's like they are performing a dual responsibility that can be performed by each other, because the main function is to investigate these issues that has to do with crimes and has to do with financing crimes and other things related to finances and also corrupt practices. And that is also the function of the EFCC. So by their acts, they are basically the same. But at a time when the ICPC was in place, it was discovered that there is need, because of the rampancy and because of the huge happenings of these crimes within the state and even outside the state. I mean, within the corpus of the state and outside it, I mean, private institutions as well. So that is why the state sees the need to bring about another institution so that it can complement the efforts of the ICPC. And I think that is what brought about the EFCC as a commission. So basically the functions are the same, but because of the rampancy, like I said, because of the rates at which these crimes are being committed, especially within the government as an institution and also in the private institutions. So that is what brought about the EFCC, so as to complement them. But basically, the primary functions are to investigate and to prosecute crimes that has to do with finances.
Now, if the two of them are basically doing the same thing, that means that their jurisdictions are overlapping, and this can actually lead to some form of confusion or whatnot, because most people actually get confused when the both of them are doing the same thing. So is there any legal clarity on how, the conflicts, the jurisdictional conflicts, when it comes to what they do, are resolved? Because for me, I would say, why not have one body handling this thing instead of having two bodies that are doing the exact same thing? What's the point? So what legal clarity, what is there any legal clarity on how, the conflicts between what they do and their overlapping jurisdictions are resolved?
Yes, I think the issue all has to do with the one who's first in time. What I mean by first time in time is, for instance, when there is a particular complaint or a petition, maybe by a non-individual or an anonymous person concerning a particular transaction or a particular activity that is suspected to be a crime that has to do with finances, the person who is lodging that complaint has a choice of where to lodge the complaint. If the complaint is at the EFCC's desk for the first instance, then the EFCC will go ahead and investigate, and if need be, at the end of the day, prosecute such suspects or prosecute such offenders. But when it is at the desk of the ICPC in the first place, it is the responsibility of the ICPC to make sure that it investigates and also possibly, at the end of the day, prosecute such matters. And also, when there are reports, they have their own ways of doing things, of investigating things, not necessarily maybe there must be a complaint. Maybe there wasn't a complaint, but then they noticed, or they, within their functions, they found out that there are activities that are liable to being suspicious. Those institutions can clearly swing into action and start. So by the time the first institution, or let's say EFCC, begin commencement or commence an investigation in respect of a matter, then the ICPC will not be liable to begin any investigation in respect of that matter, because investigation is already in place. So when that investigation is in place, the other agency will not be able to carry out any investigation in respect of such issues. So as such, when a person is being investigated by any of these agencies, if he's investigated by EFCC, for instance, in respect of the same issue, then ICPC cannot delve in and begin or commence another fresh investigation in respect of that issue until the EFCC is determined at its own level, on the level of its own investigation, and then maybe if there is any fresh issue, the other institution can investigate. So it depends on where simply the investigation is in place. If there is pending investigation in respect of one, then the other is not expected to delve in and start another fresh investigation. And likewise, prosecution. When you're prosecuted by the ICPC on an issue, whether you are being convicted or you are being discharged at the end of the day, then the other agency cannot, by law, begin another investigation in respect of that issue and also possibly prosecute in respect of that issue. That is what we call double jeopardy in law. A citizen is not allowed by law to be susceptible to double investigations or to double prosecutions in respect of issues that are the same in nature and that gave rise to the same course of actions before the court.
All right. Now, looking at arrests being made, now most times when arrests are being made either by the EFCC or ICPC, the public hears about it in some cases, but most people don't understand the legal process, that follows from the point of investigation to arrest to conviction. So, what can you walk us through what the legal process is like, when investigating corruption cases?
Yes, the process is that whenever there is a complaint, normally what these agencies do is they invite, and the invitation will be extended to the person, sometimes a writing, or rather mostly a writing. You'll be written a letter, you receive a letter from the institution that you are being invited to appear before so office on so date, and even contact will be provided that when you reach there, these are the contacts that you call, and then they'll allow you in, and then you reach the next officer, and then you're introduced, and then you are assigned to a particular department, because they have several sections at each of these bodies, depending on the nature of the offense that you are alleged to have been committed. So the moment you appear before these officers, First and foremost, you'll be introduced to the complaint or to the issue that is defined as the reason for your invitation. When you are able to go through that, you understand why you are there in the first place. They will explain this to you, and then after that, then they will hear from your own side. What is your own response to these issues? These are the allegations before them. So immediately after that, possibly, of course, before even your invitation, the person who laid the complaint must have adopted his complaint. That is what we call adoption of complaint, whereby he made his statement before them in respect of the complaint or his petition that he brought before the agency. And then as the suspect appears, he also make his complaint. I mean, he's also make his own statement. He will state his own version of the story as far as that suspected crime is concerned. Immediately after that, they will continue with their investigation. What's the general system always appreciate about these agencies is that even before your arrival, they must have raised a case of reasonable suspicion against you, so that when you come, they will just hear your own part, and then when they heard your own part, they will continue with their investigation. At that level, you'll be granted on bail to a surety. They have their own level of conditions that you must provide so person of so standing who will stand for you as surety, because at that time you are a suspect already. Then you'll be taken on bail. When you are taken on bail, they will continue with their investigation. When they conclude with their investigation, then that is where, when they found you liable for prosecution, and then they'll proceed, the legal department will proceed and file charges against the person or the suspect before a court of law. When you are not found liable for anything as far as the investigations are concerned, that's the end of the case, and then they'll release you, and then you go, and that's all. So it's critical, so to say, because the level of expertise that these institutions have, the level of know-how that they have is always appreciable. We always find it as legal practitioners distinguishable from what we obtain in other agencies that do investigate cases that does not have anything to do with financial crimes.
All right. So, what about if the person being invited does not honor the invitation or does not show up? What then will be done? Would the person be arrested immediately, or what steps will be taken, to get the person to come and answer, for the investigation?
Yes, it depends on the nature of the person. Sometimes there are artificial entities that are liable to being investigated by these agencies. This has to do with maybe companies, for mostly financial institutions, banks, and other things, and even sometimes also non-financial institutions. So when this nature of suspects are to appear before them and of these agencies, then the next line of action is to arrest. And the law has allowed them to do that. The positions of the Administration of Criminal Justice Act is very clear, and also the provision of Administration of Criminal Justice laws of the several states is very, very clear. So that is when they proceed to the level of arrest. When you defy invitation via any means to secure your presence, the law allows them their liberty to proceed and find their ways of finding out the whereabouts of the person or the suspect and ensuring that he is brought before them for justice. The whole essence is to secure the presence of the person before them. So the means, first and foremost, is the invitation. When the person defies the invitation, then that is when they have no option, they have no alternative than to proceed to arrest the person and brings him before them. And the thing appreciable as well about them is that despite the fact that you are being arrested before you are brought before them, that does not take away your liberty at the end of the day to be granted on bail. You go from there, and then the next day maybe they'll put a reporting date for you within which you will be appearing while their investigation is going on, and then at the final level they decide what to do depending on the outcome of the investigation. So the next line of action, usually after an invitation is defied by a suspect, usually is to arrest the suspect and brought him before them for the investigation.
Now, there have also been cases where some arrests, when they are taken to court, they fizzle out. Let me use that word. They fizzle out due to technicalities of some sort. So now, what would you say are some of the major legal obstacles that prevent these anti-graft agencies from actually securing these convictions, particularly when all the investigation proves that this person is guilty?
Usually, of course, we see A lot of times before the courts, these issues happens or they occur day in, day out. And mostly this has to do with a lot of things. These institutions are manned by individuals and they are being operated by individuals, so they are not expected to be perfect, but so to say, they're doing their best. But the obstacle most times that happens that you find it at the end of the day that the suspect or a defendant before a court is being checked out by the court for the purpose of the case that is pending against him. Sometimes it has to do with poor conduct of the investigation because every level of investigation is being teleguided by the law. And where any aspect is found to be lacking, as far as the proper conduct of the investigation is concerned, then definitely the court will have to look into it, and then it will do the necessary thing. For instance, sometimes securing witnesses proves to be difficult for these institutions. So when individuals or public citizens do not cooperate with these institutions, they might not be able at the end of the day to attain the goal of achieving conviction in respect of these crimes. You find out that it is very, very difficult sometimes to secure the presence of witnesses, as I said, because these people are not the people who are not the only ones who are going to give evidence in respect of those suspicions that are on individuals' neck. It has to do with members of the public sometimes members of public institutions. If they are government organizations, you find out that they'll be extending invitations time and again and court summons as well time and again so that a witness should come to court and testify against the suspect. But at the end of the day, that suspect or rather that witness will not appear to give evidence. So by the time there is no evidence before the court hands are tied. The court is bound to allow the person to go because there is nothing before it to use and also to convict the person. So these are one of the issues. And sometimes as well, there are issues that has to do with delays sometimes in the conduct of the case by virtue of the attitudes of the counsel who are appearing before the court in respect of the case. This has to do sometimes with the prosecution counsel and the defendant counsel. So you find out that the court or the case lingers for a while without the necessary expected step being taken in the matter. So when these things happen, the court will not allow the criminal charge to be hanging on the neck of the defendant in perpetuity. So when he appears in court once, twice, thrice. In fact, the Administration of Criminal Justice Act and also Administration of Criminal Justice laws of states defines the numbers of days that a person is allowed to apply for an adjournment in a particular criminal matter. So by the time you have exceeded those days and you have not been able to attain the necessary height in the matter, then the court is at liberty to strike out the charge and also allow the person to go. And sometimes as well, another obstacle is at the point where the court granted the defendant on bail, but unfortunately, for one reason or the other, the defendant might not be appear for any reason before the court in order to continue taking his trial. The agencies are doing their best. They have done their own. They have brought the person to court, and the court granted him on bail. And the court also is not Father Christmas. It always grants these bails with conditions. But as humans, you find out that people surmount these conditions and they abscond when they are on bail. So it now behoves on the prosecution and the court to secure the presence of that person either by rearresting him and bringing him before the court to continue taking his trial. So you find out that these people abscond sometimes and you have nowhere to find this defendant, and possibly that's the end of the case. So a lot of things forms obstacle to the attainment of maximum success by these agencies in terms of investigating and also prosecuting these cases. And you also find out that these agencies sometimes complain of inadequate finances. Yes, they are being financed by the government, but investigation is naturally capital intensive. It takes a lot of things. You find out that, for instance, here in Birnin Kebbi, where we are using for the purpose of our complaint and also investigations, the EFCC office that is close to us here in Sokoto, you find out that a suspect is somewhere in Lagos, for instance, or the suspect is in Port Harcourt, and they have been extending invitation to him from Sokoto to appear in order to answer to a petition or a complaint against him, but the person will not come. So these agencies have to start tracking the person. They have to start toiling him to Lagos, into Port Harcourt, to Enugu, to all parts of the country in order to secure his presence. And they don't charge the complainant for the purpose of doing this. It is out of the corpus of the government, corpus of those agencies, that they carry out these things, and a lot of other logistics that needs to be available to them for them to be successful in conducting their investigations, and also that will give rise to a possible success in court, because a poor investigation will never yield a successful conviction. It is only a proper investigation that is liable to give success as far as prosecutions is concerned before the courts of law. So there are a lot of them. These are just few instances of the obstacles that can come to mind now, and that is it.
All right. Now, you mentioned about the number of times that the defendant can appear in court, and the number of times the case can be adjourned before it is being let go, right? But we also see many cases where a particular case drags on for years and years and years without resolution. Does it mean that this time frame, you know, does not apply to those people who their cases are being dragged for years? What exactly is it, that there are loopholes in the Nigerian criminal justice system that allow for this kind of delay? What exactly is the reason?
Well, as far as the Nigerian justice system is concerned, yes, of course, no man-made law is perfect. That is what the jurists will say. But then this law has done its best. I think there are adequate provisions that has to do with issues of prosecuting these cases within the shortest possible time. It surprises you to know that the administration of criminal justice law has even provided for day-to-day trial where the circumstances warrant. So there are adequate provisions actually that can create a speedy dispensation of justice in respect of these cases. But like we always say, and what is before the court is always a practical thing. And there are circumstances that may arise that the court has to look at the interest of justice. When we say overriding interest of justice, it means other factors that the court has to consider as far as doing justice to the case. Justice not only to the defendant who is standing trial, there is also justice for the prosecution, meaning the state, that is the public. So it's a three-way stuff. But nonetheless, that sections of the law, usually, I think, if I can recall vividly, the administration of criminal justice law only provides for 5 adjournments at the instance of a party. Meaning, if the prosecution come before the court today and they apply for adjournment for any reason that they are not ready to continue with the matter, and the next day they do that, the next day they do that, another day they do, by the time they are able to do that 5 times, then the law says they are not at liberty. They don't have any more the right to apply for an adjournment before that court at their own instance. Likewise, the defendant, if you exhausted those 5 adjournments, then you cannot come back and start applying for an adjournment again. But like I said, it will go back to that issue of what is practical before the court and also the surrounding circumstances. There are circumstances that may arise that this adjournment has to be exceeded, but not unnecessarily. The court has to be convinced that there are genuine reasons. Moreover, there are authorities, meaning decided cases of the courts that interpret those sections that have to do with the limits or the number of adjournments. The court says those sections are growing trees. When we say growing trees, we mean those are things that we are trying to develop within the system. We are not expected to strict so and so, meaning strictly abide by the sections in the present era that we are. But those are aims that we aim to achieve as far as the system is developing. So it is not a hard and fast rule that the court must distinctively stick to those 5 adjournments, but when instance warrant, the court is at liberty to move and do the right thing as far as the justice of the case is concerned. But for what I can say and for what the experiences that we have in court, the courts are doing their best, because I've seen instances, that I've seen cases where the prosecutions are being invited by the courts to understand that they have limits as to the adjournments or number of adjournments that they can apply in respect of the case, so as to try to see that these cases are dispensed within the necessary time, so that the defendant at the end of the day will know his fate, whether being convicted or whether he will be eventually discharged by the court.
Okay. Now, just one more question before we let you go. Let's talk about whistleblowers, right? Earlier on, you mentioned that a report has to be made by someone, before inviting the person that is being suspected to their office. So now, how strong is the legal framework in Nigeria when it comes to protecting these whistleblowers?
Yes, the framework, I think, by the regulation or the law regulating the issues of whistleblowers, they are strongly protected in the sense that a defendant or anyone that has to do with him or any of his freebie will not be able to discern, or will not be able to know or to understand actually from where the complaint against him is emanating. I think this is the first right step that the law has took in the first place. And also, protections are being given up to the level of prosecuting these matters, because mostly the person that brought about a complaint, or the person that triggers an issue, mostly have an insight or an idea of it before possibly approaching those institutions for the purpose of lodging that issue, or for the purpose of calling their attention to understand that this is what is happening. So from the level of investigation and to the level of prosecution, those things are distinct, in the sense that at the level of investigation, there might not be a moment where the defendant and the whistleblower, or the person who lodged the complaint, will sit in one place or on the same table to discuss anything. So, and they will not see, for any reason, in the conduct of investigation, the name of the person who is lodging the complaint. What you are at liberty to know as a defendant is, this is the complaint against you. Sometimes the name of the complainant immaterial, because the law does not mandate that a complaint must be lodged by individual before these institutions can be able to carry out investigations with respect of issues, and also possibly prosecute those issues. So, proceeding to the level of prosecution as well, when you look at the appearances in court, particularly issues that has to do with giving evidences before the court, you look at it in the sense that the prosecution will not give a hint sometimes of the actual person who is going to give evidence in respect to a particular matter. Yes, the law is clear that document must be front-loaded as far as statements of suspects, statements of witnesses, statements of victims, if any, that was recorded during investigation. And also, it is those people who will be able to appear at the end of the day to give evidence in court. But the law allows a particular limit to which such disclosures will be made. For instance, the actual name of the person might not be necessarily disclosed when filing this proof of evidence, meaning the defendant side and his counsel will not be able to know who is actually the person who is coming to appear. And
All
also,
right.
beyond that, yes.
All right. Thank you. Sorry for interrupting your line of thought, but we've run out of time. Thank you so much, Mohammed Usman, a legal practitioner. Thank you for joining us.
Thank you for having me. Have a nice day.
Have a nice day.
Save Nature TV, news in your pocket.